Hello. So, as we have informed before, today's session will focus on PoSH over the past decade. We believe that we have an extremely experienced and expert panel to highlight the kind of changes that have been witnessed ever since the inception of PoSH and ever since this legislation has come in force, and also to talk and delve into the nuances of anti-sexual harassment law and the legal framework as it applies in India. Now, this event is special for us on two counts. Not only is this one of the first few offline events that we've had since the pandemic took over, but we at Himmat, we've always wanted to do whatever we can to encourage students to learn more and more about topics that are so very important, topics that are so very crucial and have a hold over our everyday life. Which is why when we came up with this essay competition in collaboration with Khaitan, we believe that this would encourage students to start asking questions, start learning and educating themselves more. And it would allow us to engage in a meaningful discussion on a topic that is so very important and so very necessary for us all. Now, I'll briefly introduce our panelists today. First, we have Professor and Advocate Ms. Chuna Sen. She's currently practicing at the Calcutta High Court and the Supreme Court. Ma'am's research interest lies in the intersection of courts and gender, citizenship and constitutionalism, and transnational feminist movements and law reforms. She interrogates the multiple ways courts and legislatures accommodate, negotiate, resist, and facilitate the agenda of post-colonial nation-state. And her current research has two broad themes. She focuses on the framework of governance feminism to locate how gender enframes the law at the workplace and how workplace is regulated and engendered by courts and the legal framework at the legislatures itself. More broadly, Man looks into the women's movements located in India and the feminist legal interventions in the 1970s, and beyond that, the informed and transformed legal reform processes by the legislature and courts. She has an excellent knowledge of the legal history in the Indian subcontinent, and more specifically, the gendered history of the legal profession in India, and the history of partitions, borders, migrations, citizenship formation, and how all of this has an impact on the legal scenario. She holds an undergraduate law degree from the Symbiosis Law School, Pune, and a postgraduate law degree from the University of California. She's also been an American Association of University Women's International Fellow, a member of Translocal Law Research Group, and a researcher with South Asia Institute project titled The 1947 Partition of British India, Humanitarian and Demographic Consequences.
So I was thinking before the session starts with the introductions, okay, we'll fix 201. It would be more comfortable. Otherwise, putting you through this for 1 hour more. Let's shift them. The ACs are working. So
right for working women, the right to work a workplace without, I mean, a workplace where there would be sexual harassment would be violative of the woman's right to woman's right under Article 14, 19, 21. So this is how the court reasons. The court frames this guidelines. The court identifies what sexual harassment at workplace is. It actually gives a definition of sexual harassment at workplace. This definition, incidentally, is taken from CEDAW. Why? Because the interveners there showed that, see, there is CEDAW. There is already a conversation of sexual harassment at workplace happening, and CEDAW's language, incidentally, also is very strongly, it derives from the, from US, from the American understanding of sexual harassment at workplace. So this is the definition of sexual harassment at workplace, and it casts a duty on the employer to provide a workplace free, which sort of tunes to the dignity dignity of the woman to work free and fairly without any form of harassment. Um, Now, idea was that you have a set of guidelines, and then eventually the legislature will step in, and that's what is noted by the court as well. Well, the legislature did step in, but the legislature stepped in very late in 2013. So between 97 and 2013, what happened? And suddenly, what happens in 2013 that allows the legislature to hurriedly think of this as an issue important enough to be legislated? Now, I'm not saying that there were not bills. There were several bills actually. There were bills which were drafted. There was an NCW bill. There were bills which were presented before the Parliament. But anyway, none of these the bills lapsed. In 2013 is right after the Nirbhaya case. In 2012 December, the Delhi, the brutal gang rape in bus happens in Delhi, which is more infamously known as the Nirbhaya case. And after that incident, the state again steps in under public pressure to form a committee. So you have the Justice Verma committee. I mean, just see like how this is like a circle of life. Justice Verma in sexual harassment, who was the author of Vishaka, and then you have Justice Verma in the as the convener of the committee. So in 2013, the Justice Verma Committee submits its report. The Commission submits its report, and it submits its report after a thorough deliberation with all stakeholders. What does the Commission state with reference to sexual harassment at workplace? It tells the state to act. It says that this was something that was supposed to have happened. It recognizes sexual harassment at workplace as something that needs a legislative intervention. It points at Vishaka. It states that the Vishaka guidelines has been there, but Vishaka guidelines being guidelines, there is no real way to implement them. And we have actually seen that happen in Medha Kotwal Lele and in a number of other cases where petitioners had to, from time and again, they had to go to the court and say that please, this is not being followed. So then the Central Civil Service rules is amended, and the sexual harassment is inscribed into the text of the CCS rules. You have petitioners coming in, and there are several studies that point out that private entities, private corporations, they're not, public bodies are mandated, but private bodies are not really living up to the Vishaka guidelines. So there is, of course, there is this proverbial minion slip between the cup and the lip. So then when the Justice Verma Committee gives its recommendation, and this is in 2013, you see like a series of laws, gender-based laws being passed. There is an urgency. The state feels that there is an urgency to, for whatever reason, one can actually go into a thorough critique of that. I'm not getting into that critique right now, but there is a sense of urgency, like a palpable sense of urgency, which the state feels that that they need to cure, or they need to intervene in order to get the law in place. So in 2013, without much discussion, in fact, it was passed practically in a day, without much discussion or deliberation, the Sexual Harassment Act Workplace Act the bill is passed, and then it receives the assent of the president, and it's notified in the Gazette, and it is passed. It is made a law. So it should be a cause of celebration, right? Now that you have an act, you have a law. This law should be able to cure you from, all ailments under the sun. So I'm not getting into the discussion on like how the law, where the law has failed, or how far the law has gone, or what the law has done and what the law has failed to do. My wonderful panelists will get into that. But to give you because my second mandate is to just tell you about the structure of the law, and I'm going to be very brief about that. The most important part is, of course, there is a recognition of sexual harassment at workplace. There is also a very expansive definition of workplace that has been provided. So workplace is not specifically the physical workplace. So if you're working in an office, if this is an office building, and if there are 20, 30, whatever number of employees, that office building itself is not a workplace. Workplace is also an extension of workplace. So if there's a sexual harassment that takes place between two employees in the course of work, even a moving car will be considered a workplace. So that's a very interesting thing, and that's actually a fantastic thing, the recognition of workplace itself, because it makes things so much easier. Because workplace is a very diffusive concept, especially now. When you're working from home, what is the workplace? Is the internet? Is Zoom a workplace? You're communicating, you're corresponding with your colleague on Zoom or MS Teams or whatever. Is that a workplace? So the definition of workplace has been deliberately kept somewhat broad in order to kind of contain all these complexities. The third one is that there is a specific duty cast on the employer. It is not, if you look at the definition of if you look at the title of the act, it is not just repressive. There is prohibition, there is prevention. So you need to what the law is trying to say is that the employer needs to prohibit. It's not just enough to redress. So you do not sexual harassment an inquiry process under the sexual harassment law, under the PoSH law, does not just start with the moment there is someone files a complaint. Uh, there has to be an active role on behalf of the employer to prevent, to prohibit sexual harassment in the workplace. And what does the employer need to do? There is a detailed kind of chart. There's almost like a charter for that. Even the employer needs to consider. Of course, the first thing is you have to consider a committee. You have the information that there is a committee to redress sexual harassment at workplace. That also needs to be made known to the employees, and so on and so forth. So these are the three most I think significant parts of the law. One last significant part of the law is that it actually it understands that the institution is a very complex space. There may be power dynamics involved. So in order to ensure that the process is fair, it mandates that there has to be one external member on the inquiry committee. And the inquiry committee has to be headed by a woman, and minimum 50% of the IC has to be women members. There are all these. I think I'll stop there. I think I've gone beyond my 15-20 minutes, whatever was allotted to me. And yes,
Okay,
thank you.
Thank you, Professor Sen. That was very, very enlightening, particularly when you trace the history. And the thing which which strikes everybody is the way mindsets work. So it takes an atrocious incident for people to wake up to change the laws. So this was a great initiative on Himmat to organize this, because I feel one main problem is no matter what, there is still a lot to be done in terms of changing mindsets. So now that Professor Sen has given us an idea about the evolution of the law, the history, and beautifully weaving it together, right up to the Varna Committee and the enactment of the Act and the reasons, the undertones as well, I would request our next speaker, Ms. Himmat-Khaitan, to tell us more about the implementation of the law and the practical experiences. Yes, Nandini.
Hello. This was a master class, and this should be put down. I'm going to be using this YouTube if it's available later on for further research. Outstanding. I mean, I wish you could take the whole panel only.
I wish you could be our external in the IC.
It's been nearly 10 years since the Act has come out. In my daily workings as a law firm partner and an advocate in the High Court, I work with a lot of clients, right from individuals to multinationals to public sector companies. It is surprising how many people till date have no idea about the law, and even if they know about the law, they have no idea about what they are supposed to do with it. Last week, there was a client who came to us. He was wanting to set up his practice for something, and he would have about 20 people in his office. And of course, the priority was to get the trade licenses and the fire licenses and all of that. And then I said, what about, have you set up an ICC committee? And they were like, what is that? I mean, there was genuine flummox at that. They had no clue. And let me tell you, this particular person is not in the minority. It is usually the question that I'm asked when I say, do you have an ICC committee? So very well, we said that this is the ICC committee, you must form it, it's under this law. Next question that I was asked was, can we have our own people who support the findings that we wanted to be found? It was shocking. It is absolutely shocking. Um, well, not only do you need to form a committee, you also need to do sensitization and awareness programs maybe 2 to 3 times a year for your entire organization, and it has to be done diligently. And the report, I mean, the fact that you have done it, and if there were any complaints put to the committee, have to actually all be reported to an authority which has been notified under the Act. Let me tell you, most places don't know about this. The compliance issues are sadly lacking. There's in fact there's a penalty also, a small one, but there is, but most people are not aware. And it is shocking that 10 years later, this is the level of sort of unawareness that's prevailing. Um, One of the things that Professor Sen touched upon was the formation, I mean, of the committee, and how the law came about. But there was a discussion in the before the passing. I believe you said it was a day, it was passed in a day, but there was discussion earlier on why is the PoSH Act not gender neutral. It should be gender neutral, and I'm touching upon this only because the mandate given to me for the discussion was that, discuss a little on the diversity part and the queer part and all of that. So the idea behind it to be only related to women was that till date, the atrocities and problems faced by women were, was, far, far, far more than anything to do with men, any problems that they faced. So it should be only women-centric for the time being, because, it's like a 498A situation where you do have false cases, but the number of genuine cases are so much that the false cases, sort of seem smaller in number. So then, the idea was to have it only for women. The problem with that is that, uh, so in today's dates, when companies now come to us, that we've had this, sort of complaint, or they want to set up their policies, it's very loosely called a code of conduct in a lot of places. They have to set up two sort of committees. One under the PoSH Act, which is for women, complaint by a woman. It could be against a man, or even that matter for a woman, not technically in that sense. But if a man wants to complain, there has to be a separate committee. It's usually a grievance committee or a redressal committee, but call it any name. So that's what happens in today's day and age. And one of the issues that we saw recently was there was a transgender woman who wanted to complain against under the PoSH Act to the ICC. And well, there was a issue raised that how can she complain against to the ICC? Is she even covered under the PoSH Act? So these are practical things that one sort of comes across when you're dealing with these things. Professor Sen also touched upon the issue of workplace. What we have seen is, yes, it's not just a building. It's not just, it could be a moving car. Interestingly, we've seen very often issues of these offsites. Companies have offsites, and you're taken to some retreat place, and there's everybody's drinking, dancing, and there's some incident occurs, and the accused said, "Well, we were not at work. We were, But anything which is related to workplace, even if it is not at the workplace, will amount to an incident under the PoSH. And we have seen this increasingly in terms of how PoSH is looked at and how the definition of workplace is looked at. And the moving car incident that she said is absolutely correct, because a lot of we've seen a case where there was carpooling given by the company, and an incident took place in the carpool. And the defense, of course, setup was that it was not at work and they were in a casual environment where they didn't feel the need to be, formal. Another very important aspect of a practical aspect of the PoSH Act or in its implementation is it's not about what the intention of the accused was, rather how it was perceived. This is something very, very nuanced. Today, a man might compliment a woman saying that it's a beautiful sari, and he means it just as a compliment and nothing more. But if the woman finds it to be, harassment in any way, it could be an issue. So while I'm making this a very simplistic example, but you would be surprised at how many times the defense that we see in the ICC committee is, well, I didn't intend it that way, or I didn't mean it that way. Sharing of a joke, like you get memes and forwards on your WhatsApp all the time, and you keep forwarding it to people. And so, for example, in one case, one of the complainants said that, well, I was asked what did I do on my honeymoon, and the question was put by a man to me, and I felt very harassed by that question. And the man said it was a general question. She had just come back from her leave, and she said no, he had no business asking me such a personal question of this sort of an intimate nature. And of course, the committee found whatever it needed to find, and the man apologized in the end. But I'm just saying that it's about how it's perceived rather than how it's intended, which is important, and people need to keep that in mind. There could be people who are very sensitive, and one needs to be careful about that. The next thing I want to touch upon is the formation of the ICC itself. It is a minimum requirement to 4 people, where 50% are women, and it's chaired by a woman. Uh, you know, we've also had cases where there was an organization. So the ICC needs to be formed if you have 10 people or more in your organization. Otherwise, it goes to a government-formed local committee. So what we have seen here is that a company told us that, listen, we are an all-male organization. Not that we intended to be that way, but it is just an all-male organization. What is the need for the ICC? Because there is no woman here. But the logic is that it's mandated under law, and you'll have to figure out a way how to induct women into the ICC. But the reason for needing the ICC, despite being no women, is because they may interact with women. So suppose a salesperson walks into the organization and faces an incident, or there's an intern who's a woman, or there is a third-party vendor who's a woman, and they interact and there's some incident. So the committee formation is important even if you don't have women in your organization. You'll have to see through that. Um, a very, very important thing which we don't realize until we are part of a committee or dealing with such issue is interim measures, which as a high court lawyers we all know is how the courts function these days. It's all on interim measures very regularly. Final hearings come at a belated stage. Now, the ICC committee X number of days.
I'm not very clear on what it, and I mean, somebody not having faith in the system, so are they justified in calling out on a public platform? Or could you like, could you reframe it?
So essentially, if there has been a call out and no formal proceedings have been undertaken by with them, in that case, there's an interim period when everyone knows about what has happened. But like the interim period that ma'am mentioned, we have an end to that. So the ICC
No,
comes
this
out
is
with
a
a
very different. This is a different interim period. What ma'am is talking about, or what ma'am has mentioned, is after a case has formally been filed before the
exactly. But
ICC.
here, and in the case that she mentioned where sometimes there have been leaks of mails and things like that where everyone gets to know.
Hmm.
So in such a case where there's no formal
And that's going to take, yeah.
Uh, what is what are the people around supposed to consider of the situation? Are they supposed to um, wait for the victim to probably take course of action?
I'm just interrupting. Are you talking of whether IC can take so much of cognizance of the matter or something like that?
Yeah, or what can the IC do better to probably have people have faith in the IC?
ICC committee generally works on a written complaint. That's a mandate under the Act. So you have to have a complaint. It doesn't have to be by the woman herself if she is not empowered. It can be through a relative, friend, anybody who can represent her, but it has to be a complaint. As far as how, if she does a call out in social media or whatever on her own, for whatever reason, it might be justified, it may not be in some case. How do you treat the person? Well, the company, there would be some kind of an obligation on the company to just look into it. The company would have expected a complaint to be voted through them, through the ICC. They would also have to then look into why they felt compelled not to come to the ICC and go public or go outside. You can't really question the right of a person to go to a police station or to court under law if they have a case under it. But really, if they bypass the system, that would also require some sort of a uh, reason behind it. And if there is a genuine reason, then it would be dealt with accordingly. And as far as how do they treat people in the interim, that's really something which is human sort of nature. I think there will be sympathizers and there will be people who are anti those people who will do this. So the people who are friends of the accused will say that she's or he's done something wrong, and the people who support the complainant will say that good for her or him, and all of that. That's really a human sort of interaction that will come into place. But as far as the ICC's complaint is required, you need a complaint.
So, just to answer, add on to that, I understand your query. See, the thing what happens, and I tell this to ICCs when I train them, okay? Complaints never, like in 90% of the cases, complaints do not come as a very straightforward thing. That somebody has gotten up, decided, asked to case file karna, and I've gone and written a beautiful complaint and come to the ICC. It doesn't work like that. It's a complicated, messy process. I am going through something which is, I perceive it as sexual harassment, and what am I going to do about it, right? So there are so many things a person goes through in their mind. They may not believe the system. Like, your question is, they may not believe the system. They may want to publicly call out the person. They may want to write an email. I have had situations where a woman has written an email to the entire team of a company without even approaching the ICC first, because she did not have any faith in the entire system, first of all, and secondly, she did not even have an idea that ICC existed. So the only thing she could do was write an call out email. Right? Now, in all these situations, what ends up happening, and again, the reason I'm pointing this out is a messy process, is because what ICCs also, and here that is where the authorities in terms of ICCs or the HRs need to step in. Where when you know something like this is happening, at the end of the day, written complaint, right? But you need to call the complainant and first inform them of their rights as well. Tell them that there is this process. Do you want to do this? These are your options. So a lot of times it has happened in my experience where complainants have come and complained to, let's say, ex-member of the organization, but say we don't want to file a formal complaint. We have to set up a meeting with the complainant and talk to them and tell them their right. Do you want to file a criminal complaint? Organization is supposed to help you, and we can help you with the police complaint if you want to. If you want to file a written complaint and you are unable to do the written complaint, at the end of the day, the law says if a woman cannot write a complaint, ICC has to give her all reasonable assistance in filing the complaint, in writing the complaint also. So, as an ICC, it also becomes our job to help a person write the complaint, help them put it down, in the written medium. So, point is, yes, it's a messy process. Not everybody goes through their own journey when they're filing a complaint. But at the end of the day, that's where again, it all comes around in terms of how whoever is in an organization or a college or wherever they are, how they are supporting that person in terms of telling them first what are their rights, what do you expect, and what do you want to do at the end of the day. Secondly, I want to take up the question that Tejaswini you raised about the timeline.
Yes, see, the timeline is there for a reason. Let's also understand that ICC has 90 days plus another 90 days discretionary period, which gives them effectively a 180-day timeline, right, for a woman, for complainants to come forward. Now, the timeline is also given so that we have to